Good afternoon, everyone. My name is Raquel Guzman. I am the account manager with Momentum Events, and it's my great pleasure to welcome you here today for our session. Before turning things over to our presenters, I'd love to just state a few words of note. First off, this session is being recorded. Everyone on the call will automatically receive an email from us containing a link to the recording that you can view or share with your colleagues after. You'll get that in the next 24 hours or so. Also, the presenters have agreed to make copies of the slides available, so stay tuned for the end of the presentation where you'll see their contact details. Finally, the presenters will be conducting a Q&A at the conclusion of the session. To pose any questions to the panelists, I ask that you please use the question pane, which you'll see on the right-hand side of your screen. With that, it's my great pleasure to introduce Mike Barnett, Lindsay Hines, and Jim Muehlberger from Shook, Hardy, and Bacon for today's webinar entitled The Cannabis Conundrum, the Evolving Landscape and Risk Mitigation for Hemp and CBD. Now over to you, Lindsay. I'll hand it off.
Great, thank you. Good afternoon, everyone. I'm Lindsay Hines, and I'm a partner at Shook, Hardy, and Bacon here in our Kansas City office. And I, along with my colleagues Mike Barnett and Jim Muehlberger, are going to take you through the legal issues affecting this industry with a particular focus on the issues that companies interested in utilizing cannabis-derived ingredients in food and beverages should keep in mind. So as I'm sure you've all seen, cannabis, hemp, and CBD products have become a hot topic, and we're seeing these products come up more and more in the news. These are just an example of a few headlines. This first one, for a buck and sometimes a buzz, brewers are putting cannabis into cans. I should point out that, as you can see, that headline was from November of 2018. As some of you may know, since then, the TTB issued an industry circular confirming that the TTB will not currently approve the use of CBD in the formulation of wine, beer, and liquor. So I'm sure those manufacturers are now sorely disappointed. We have Seth Rogen launching a weed company to, quote, make it easier for people to learn to love cannabis. And futuristic farming is here. Got hemp, new regulations for CBD products. You know, Martha Stewart is now interested, which definitely means this is becoming a trend. And is CBD helpful or just hype? And then we have some other headlines here. You know, cannabis in your coffee, but is it legal? And that's really the question of the day, right? Needless to say, these products are of interest, and consumers, regulators, and the media, again, are taking interest. With all of this interest, the CBD and hemp industry is growing, and these products have moved from the fringe to the mainstream. Last year, Americans spent about $2 billion on CBD products, and the market is estimated to be $16 billion by 2025. So let's talk about what some of these products are. This is just kind of a sample of the things that we're seeing. CBD and hemp are in food. We have CBD-infused beauty products. Of note, major retailers are getting in the game. Even Bed Bath & Beyond has CBD and essential oils for sale. And of course, hemp textiles are also very popular. Now, not only are we seeing a boom in CBD and hemp products, and we're legal marijuana products, of course, but we're also starting to see a trend of retail concepts for these products. As I mentioned earlier, we're in Kansas City, so we actually, Shook has a Denver office, and we asked our Denver colleague, Paul, who also does work in this space, just to take some pictures of what he sees on his drive to work. And it's pretty incredible. So I believe Paul told us that this image of Maggie's Farm retail marijuana is the old DMV, which again is now a retail marijuana space. Paul passed by this truck, which is for hemp textiles, I believe. This, I want to say, is a old gas station, perhaps, if I remember correctly. It's another Maggie's Farm, and you can see there that best meds under the sun. I suspect they might have a problem with that claim in the future. Gas and Grass, a very clever gas station / marijuana location. And then, as you can see, the CBD store is now open, so it's really a one-stop shop. Our colleague Paul, instead of going to Starbucks, can go and get CBD in his coffee. And then my personal favorite, Paul tells us that sadly this was his family's favorite Thai restaurant, which is now a retail marijuana space. So again, in addition to these products, we're starting to see these retail concepts, and really it goes without saying that this industry is very much taking off. So Mike, with a growing interest in this area, what's the reach of these products from a legal perspective?
Thanks, Lindsay. The reach is really as far as the legal field looks. Every sort of industry is having some sort of contact with either marijuana products or hemp-derived products like CBD. We've work with manufacturers, distributors, and retailers, but really the supply chain is just a piece of the sort of the legal focus in this industry. All of the entities that interact with those manufacturers, distributors, and retailers have to think about these issues as well, whether it's insurers, banks, real estate firms, or any of the vendors that work on a day-to-day basis. And these topics come up in really every substantive area. There's been recent guidance from the federal government about how you can trademark products that may or may not be illegal under federal law. You have HR and employment issues with drug testing, product liability and pharma and regulatory issues, which is most of what we'll be talking about today on the legality of these products. And the list goes on and on. We expect to see a growing interest in litigation around these products as things go forward, especially with some of the claims that are being made out in the industry that, at least in our view, opens up a lot of players to pursuit of those claims. So before we go too much further through the legal landscape, we need to identify what exactly we're talking about. And that is broadly defined as cannabis. There is a specific plant. We're talking about the cannabis sativa plant. It's an annual herbaceous flowering plant. This is a plant that's really been used throughout history. There was a CNN article from just a few days ago talking about the history of hemp, and they have found evidence in various archaeological digs back to 4,000 years ago. It was used in ancient Egypt as a fiber. It was used as rope in China. And some of the early American flags were actually made of hemp fibers because there was a large cash crop of hemp in colonial America and really going on forward. Now, when we're talking about the plants and their uses, there's a couple important distinctions to make because cannabis sativa is a broad scientific name of the plant, but this is where we get both marijuana and hemp. And both marijuana and hemp have both cannabidiol, commonly called CBD, and the more complicated one that I won't try to say, but the THC, which is the psychoactive substance in marijuana. But there are some important distinctions between the two plants. They look different, as we can see here, but that's sort of just the start of the differences. As, again, our friend Seth Rogen, who keeps coming up today, talked about in Pineapple Express, a great movie from 2008, in case you missed it. The cannabis industry is all actually very scientific. So what is the scientific difference? Well, the crux of it is the THC concentration within the plant. If we're talking about marijuana, we're generally thinking about the plant or products that contain THC concentrations between 5 and 30%. If we're talking about hemp, we are categorically talking about products or plants with a THC concentration below 0.3%. And as we'll learn, this has become an important part of the legal distinction at both the federal and the state level. And it's important because these low THC products, or in many cases zero THC products, have taken the psychoactive effect out of the cannabis industry to where you can use the products and not experience what's typically called the high associated with marijuana, and still get the benefits or the claim benefits of the CBD, which is actually present in both of the different plants. There's also, following the scientific distinction, a really meaningful legal distinction. At the federal level, marijuana is still very much illegal. It's a federally prohibited drug, and the possession can still put you in federal prison, despite the fact that the legal status in the states is continuing to evolve and is much more complicated. As of today, with Illinois adding to this column just a couple weeks ago, we now have 11 states where recreational marijuana is legal, and we have in excess of 30 states where a variety of medical marijuana uses are permitted. Now, CBD is a bit more complicated. It has been decriminalized in many effects, but we still have a lot of questions about the legality, especially of specific uses. And then the states are trying to catch up with the federal government's decriminalization and have really created a patchwork of different approaches that are really a challenge to navigate, especially for multi-state distributors or retailers. All right, so when we're talking about THC and CBD, what are we actually talking about? These are two of the most prevalent cannabinoid compounds that are included within the cannabis sativa plant, your body contains cannabinoid receptors, and the various chemical compounds in the cannabis plant interact with those receptors differently. The primary difference between THC and CBD is how it interacts with those receptors in your body. THC tends to react with the cannabinoid receptors in your brain, which is what causes the psychoactive effects associated with marijuana, whereas CBD doesn't interact with those receptors as much and interacts more with receptors throughout the rest of your body. There's actually even some studies that suggest that CBD in combination with THC reduces the psychoactive effects, but because of the recent decriminalization efforts, really the science and the established science is catching up with a lot of the claims or beliefs about both THC and CBD. So moving into the legal landscape, I talked a bit ago about the history and the long use of especially hemp and hemp-derived products throughout the world. And many of those, especially with the fibers and sort of things, are used continually throughout history up to today. The U.S. took a little bit different approach. Starting in the early 1900s, there was a bit of a, we'll say, a scare around the effects of marijuana and what happens to people when they use it. If you go back and look at some of the statements made in the 1920s and 30s about marijuana, it's a little bit shocking what was claimed, but it got a reaction, and in 1937, Congress outlawed all forms of cannabis, including what we now call hemp, which is the low THC form that has zero psychoactive effects. So they really took a broad approach on it. Now, this effort was redoubled in 1970 with the passage of the Controlled Substances Act. The Controlled Substances Act was one of Richard Nixon's signature tough-on-crime bills, and it created the schedules of drugs that are still in place today at the federal level. And it packaged marijuana and all cannabis-derived products along with LSD and heroin. And that was certainly controversial in 1970, and it has remained controversial through today. But there was very little pushback in the form of legalization efforts for more than 25 years. Not until the mid and late 90s did we start seeing legalization efforts around marijuana, and those were all focused on medical marijuana. Now, since the mid-90s, we've seen the push of both medical marijuana and recreational marijuana, and have had a little bit different track with industrial hemp. And so in many ways, the industrial hemp market has had a more accelerated legalization path, but it started really much more recently. Only with the passage of a federal farm bill in 2014 did the USDA create pilot programs that allowed for the first cultivation of industrial hemp in the United States since the 1930s. And that progress and the benefits to farmers and others in the supply chain of industrial hemp got sort of a shot in the arm just this last fall. In 2018, at the urging and with the strong support of Mitch McConnell, whose state of Kentucky has benefited greatly from industrial hemp in the recent years, there was a increase in the permissibility of the cultivation and growth of industrial hemp. And so with the 2018 Farm Bill, we first came up with the classification of industrial hemp under federal law. And this is important because with this classification, which is the cannabis sativa plant with lower concentrations than 0.3 of THC, we decriminalized industrial hemp for the first time. So now the possession and use of industrial hemp is no longer an issue that the DEA and other criminal enforcing agencies focus on, but it is still very much an issue within the federal government, and a number of federal government agencies, along with state agencies, continue to be interested in the cultivation and growth of industrial hemp, and maybe more critically, the distribution and sale of products containing CBD. For example, the USDA is still governing the pilot projects under the 2014 Farm Bill and has not yet issued regulations under the 2018 Farm Bill, although we hope to see those soon. So we have not actually had any industrial hemp grown in the United States under the 2018 Farm Bill because the USDA hasn't yet said it's okay. We have similar complications with the FDA and the use especially of CBD. And to talk more about that, I will turn it back over to Lindsay to walk through the FDA and state agencies' treatment of CBD and other hemp-derived products.
All right, thanks, Mike. So we're going to talk about marijuana a little bit later, but due to the consumer product landscape in the United States, we're going to focus on hemp-derived CBD for now. So given what Mike just told you, does this mean that hemp-derived CBD products are legal now? And as you can see on the slide, the answer is no, far from it, but it's confusing to say the least. Let's start at the federal level. So the FDA regulates all CBD products, and I think it's helpful to think of these products in kind of two buckets, non-food products and food products. So first, with respect to non-food products, you can't make a therapeutic benefit claim or other disease claim without FDA approval. And that's pretty straightforward. Where things get a little bit more confusing is with respect to food products. So today, under the current state of the law, it's unlawful to introduce food or dietary supplements containing CBD into interstate commerce. And here's why. I think it's helpful here to have a little bit of a background. So in June of last year, FDA approved the first drug in the United States that contains an active ingredient derived from cannabis, and specifically that active ingredient was CBD. Now that drug's called Epidiolex. It's available now. As I said, it's FDA approved, and it's used for the treatment of seizures. So because FDA has now approved CBD as a drug in this context, the agency's position is that CBD now can't be added to food or dietary supplements, or such products would be, quote, adulterated. So this brings us to an obvious question: why am I seeing CBD products everywhere? And the answer, at least in part, is enforcement, or really I should probably say the lack of enforcement. So again, these products are probably not technically legal, but the fact is that FDA enforcement has been scarce. Where we have seen FDA enforcement has really been focused on products that are making therapeutic claims. And so at least from my perspective, it seems that the industry at large has kind of taken a hint from FDA and said, well, we're probably okay as long as we are not making these kind of therapeutic claims. But again, the bottom line is that FDA's position is that these products are unlawful. And it's interesting, the enforcement letters that we've seen, as folks on this call may know, typically what happens is you're getting a warning letter, from FDA first. And again, really the crux of those letters is focusing on the therapeutic claim, but at the beginning of the letters, FDA is very clearly stating these products are unlawful, kind of more globally. But again, the crux of the letters have been therapeutic claim, and that's where we're seeing the agency go after folks. And now I should note here that FDA has recognized that there are 3 hemp-derived products that are generally recognized as safe. So that's why you'll see certain hemp-based protein powders, for example, or hemp hearts. I know that's something I personally eat almost every morning in my yogurt. But to be clear, that's hemp versus CBD. So again, we have these 3 hemp products that are okay, and then CBD not okay, at least from FDA's perspective right now in food. So what's the future for CBD? As some of you may know, FDA actually held a public hearing just a few weeks ago. It was on May 31st on kind of all things cannabis, so not just CBD, but also marijuana. And as things often go with the agency, we're still left with a lot of questions, but what was clear is that the agency still remains concerned about unsubstantiated therapeutic claims, and they also focused a lot on the lack of science regarding CBD and THC. The FDA did note time and time again that they understand the consumer interest in CBD in particular, but truthfully, particularly after following that hearing, we expect the agency to proceed very slowly and deliberately in considering these issues. And really, I think the only thing that might speed this along would be congressional intervention. All right, so are the states cool with CBD? Unfortunately, there's no clear answer because the states are taking very different approaches, which is leading to some uncertainty regarding how and where to proceed depending on the product at issue. And Mike kind of alluded to this earlier when he talked about the patchwork of regulation. So to illustrate that patchwork, I want to highlight just 3 examples. So kind of in the first category, we would talk about states where there's express permission. So some states have expressly permitted the sale of hemp-derived CBD to the public. And so one of those states is Colorado. So we have a 2018 law in Colorado that modified the state's Food and Drug Act to allow the use of industrial hemp in food and cosmetics. And then the Colorado Department of Public Health and Environment has published an industrial hemp policy. That policy states that the use of all parts of the industrial hemp plant is allowed as a food ingredient in the state, and it subjects manufacturers to strict sourcing and labeling requirements. Now, of course, the policy cautions that, and I'm reading this is a direct quote, this policy does not establish or infer conformance with applicable federal laws. But at least within the state, again, within state lines, these foods are expressly permissible. So again, that's kind of that first category of express permission. Some states have decriminalized hemp-derived CBD, but lack regulatory guidance for the sale of products. And so one example is Kansas. So in Kansas in 2018, the legislature passed a law that exempted CBD products from the state's criminal code regarding marijuana. So adults in Kansas can legally purchase and possess CBD products as long as they contain 0% THC. But again, this is merely implied permission. So unlike Colorado, Kansas has no law that expressly speaks to CBD in food and beverages. Now, finally, in some states, CBD is, for all intents and purposes, illegal, and Idaho is one such example. So in Idaho, marijuana remains a Schedule I controlled substance and includes all parts of the plant, including hemp. So the Idaho Code states that CBD must contain 0 THC, otherwise it's illegal. Now, notably, there's a fairly recent case that really shows kind of the confusion that can result from these kind of laws. So in this case, the Idaho police seized nearly 7,000 pounds of hemp that was en route from Oregon to Colorado. So the case, if you want to look it up later, is Big Sky Scientific versus Idaho State Police, and it was decided on February 2nd, 2019, so again, fairly recent. So this driver was transporting industrial hemp. Again, that is what it was, industrial hemp, and Mike explained the difference between these products earlier. And he was stopped by the Idaho police, which then seized the products, and the police claimed that the truck was essentially filled with marijuana, which again was just not true. This poor driver was actually charged with marijuana trafficking, so I'm sure we can all think about how we would feel in his shoes and probably just kind of an unexpected day at the job, right? The manufacturer then sought a temporary restraining order compelling the state police to release the hemp because, again, they said, hey, this is no longer a controlled substance under the U.S. Farm Bill. Interestingly, the court denied the restraining order because there was no federal regulatory framework yet, and thus the court said Idaho can enforce its own rules because, again, as I said earlier, in Idaho, for all intents and purposes, it's illegal. So the court ultimately held that interstate transportation of hemp was only protected from application of state criminal law when it was done in accordance with a regulatory framework. So as I said earlier, this kind of patchwork of state laws has made things really confusing for companies that are trying to operate legitimate businesses in this space. And I think I should also say that, again, we're just kind of highlighting a few examples because really we're seeing changes weekly, if not daily. States are slowly but surely kind of speeding up or picking up to where things came out with the Farm Bill, and I think that we're going to continue to see kind of this patchwork. I'm hopeful that in the future maybe there will be a more uniform approach, but again, particularly when it comes to food and beverage, there's just no clear answer from state to state. All right, so what about marijuana? As I promised, we were going to talk about that later. As you can see on the slide, we have 11 states now. I think as Mike mentioned, Illinois moved it from 10 to 11 very recently that have legalized marijuana for adult recreational use. And then we have 33 states that have legalized medical marijuana. Now, of course, marijuana remains illegal under federal law as a Schedule I controlled substance. And so then you kind of wonder, well, how does that work if it's illegal at the federal level and then when we have these states that have legalized it? Well, that takes us to that second bullet regarding the Rohrabacher-Farr Amendment and the Cole Memorandum. I won't get into the weeds on these, but the Rohrabacher-Farr Amendment essentially prohibits the DOJ from using federal funds to interfere with state medical marijuana laws. And then the Cole Memo essentially put a halt on federal prosecution of individuals complying with state marijuana laws, both medical and recreational. Now, what's interesting is the Cole Memo may sound familiar. As some folks may recall, former Attorney General Jeff Sessions actually rescinded the Cole Memorandum. But since then, AG Barr has said that he's not going to go after businesses or individuals that are relying on the Obama-era policy. So where does that leave us? That leaves us with a memo that was rescinded and hasn't been reinstated, but we have at least a statement saying, okay, I'm not going to go after you if you're relying on this since rescinded memo. Needless to say, it is confusing, but I suspect it will keep those of us that practice in this space busy for the foreseeable future. One important update that I want to highlight here is a really interesting recent opinion out of the Second Circuit. That case is Washington versus Barr, B-A-R-R, if anyone wants to look that up. And it was decided, again, as I said, very recently on May 30th of this year. So in that case, the plaintiffs challenged the inclusion of marijuana as a Schedule I drug, and you may wonder how they did that. Some of the plaintiffs in that case included individuals with medical conditions being treated with marijuana, yet they argued to the court, hey, we are legally using these in our state, but we can't do things like travel to states where marijuana is illegal or travel onto federal lands. And so one of their allegations is that the classification as a Schedule I drug poses a serious threat to their health. The Second Circuit ended up agreeing with the district court and said, your allegations are serious, we take them seriously, but really this case isn't ripe for review because you should have brought it to the DEA. You failed to exhaust your administrative remedies. And so the Second Circuit said, you plaintiffs need to go and take this to the DEA first, but very importantly, and I think this is interesting, the Second Circuit retained jurisdiction for, quote, the sole purpose of promoting speedy administrative review, given the unusual circumstances. Now, the Second Circuit said, we're not going to retain jurisdiction indefinitely. They gave the plaintiff 6 months to seek DEA review and inform the court. Otherwise, the case will be dismissed. But if the plaintiffs do seek DEA review and the DEA fails to move quickly, then the door is open for the plaintiffs to return directly to the Second Circuit under their retained jurisdiction instead of having to file at the lower court first. So again, that's really interesting. I think it's the court's way of trying to kind of move things along so that the law catches up to the realities of the marketplace today and the consumer need for these drugs, but we'll see what happens. That's something we're keeping an eye on. Last, I should note here that Congress does seem to be trying to take some steps to protect businesses in the cannabis industry, absent clear signals from the Trump administration or any indication that marijuana is going to be decriminalized at the federal level. One such measure that we're keeping an eye on is the Safe Banking Act, which is a direct response to the unintended consequences that have resulted from these businesses that have, in at least some instances, had to operate on a cash basis. We're seeing the banking laws kind of move along in other spaces too, but again, at a federal level, that's one response where Congress seems to be trying to take a more active role. And with that, I will pass it on to Jim.
Thank you, Lindsay. I want to spend a few minutes talking about some of the emerging legal risks of these products. As Lindsay mentioned at the beginning of this presentation, cannabis-infused edible sales are booming. Plaintiffs' counsel tend to seek out and attack profitable products, and we can expect that they'll use their successes in the food and beverage class actions in launching new labeling attacks on cannabis products. For example, I think we can expect to see class actions attacking labels that use words such as natural, pure, healthy, or 100%, or other references along those lines. We heard Lindsay mention best medications under the sun. That's probably going to attract some attention. So why do I say we're likely to see this? Well, let's take the natural claims first. These were some of the first class actions filed against food manufacturers. And many food lawsuits continue to focus on use of the terms natural or pure or 100% in labeling attacks on products that allegedly contain synthetic or artificial ingredients. Plaintiffs' lawyers find these claims attractive because of the lack of definition of what qualifies as natural and varying consumer interpretations of the words. And I think we can expect to see similar labeling claims brought against cannabis-infused edibles. In the food and beverage space, natural claims then sort of evolved into attacks on healthy labeling. Now, these cases attacked allegedly false statements such as nutritious, good for you, or even more explicit health claims like some that we see on the cannabis products. I think we can expect to see similar attacks on these new and evolving cannabis and CBD products. And sort of the third sort of broad area I want to talk about are the plaintiff testing claims. Now, what do I mean by that? Well, these are sort of the latest trend in class action filings in the food space. Plaintiffs' counsel go out and they hire laboratories to test whether the label claims are accurate. For instance, if a label states that a product has a premium ingredient, plaintiffs will test whether that claim is accurate. And if not, by relying on test results in their complaint, they hope to create a question of fact that will survive a motion to dismiss, and many times they do so. Plaintiffs' counsel have also used testing to reveal trace amounts of heavy metals and pesticides in food products, which can lead to sensational headlines and reputational harm to manufacturers. I think we expect to see similar attacks on cannabis and CBD products. Let's talk a minute about potential health risks of these products. Now, many of these products are made by treating the cannabis with a solvent to concentrate the THC. And higher THC levels lead to increased highs and increased sales of products, as we've already mentioned. The problem is that the THC in these products is typically, or can be, 4 to 10 times higher than in the natural or smoked cannabis. And the risk of these higher doses is really not yet known. Early studies, though, have reported that it increased psychological dependence and withdrawal symptoms as a result of using these products. Some case reports have even found psychosis-like symptoms. And just yesterday, the New York Times published an article advocating that given the risk of these higher THC in the products, that the minimum threshold age for consumption of these products ought to be raised from 21 to 25 because of the psychoactive effects on the brain. And as we know, in many cases, the brains of adolescents are not yet fully formed until about the age of 24, 25. Let's talk about the pesticides for a minute. There are absolutely no EPA regulations that exist controlling the use of pesticides for cannabis-infused edibles. Not surprisingly, growers use a wide range of pesticides, which is typically not disclosed in the product information labels. Now, studies have shown recently that pesticides are concentrated in edibles versus what you'd find in natural cannabis at 10 times the amount. And so we're getting some very high levels of pesticides, and in some cases, pesticides that aren't even allowed under state regulations. So I expect to see this to be an emerging problem and subject of litigation. Finally, let's talk about vaping. As you know, vaping delivers THC to the central nervous system very quickly, exacerbating the effects of these higher doses. And many products also contain added ingredients, such as flavorings to improve the taste or ingredients to mask the smell. But because these flavorings aren't regulated, they may pose a significant risk of harm. For instance, one of the flavorings being used is a buttery flavoring chemical, notorious for association with what has been termed popcorn worker's lung, which is the subject of litigation claiming lung damage. So expect to see this as an emerging area of litigation. In conclusion, I think we expect to see a cottage industry arising soon of class action labeling attacks on these products. And because the market for edibles is exploding, so are the risks associated with them. There's a real need to study and control various aspects of these new products, such as the levels of pesticides. We need to understand better the health risks of these increased THC content. And finally, there's a real need to establish some testing standards for these products. Thanks, Lindsay.
Well, before we wrap up and take questions, I thought it'd be helpful to give you just a little bit of insight on some of the work that this group and a number of others across our offices have done in the cannabis space. A lot of our work has been focused around helping industry participants and those that work with industry participants understand the ever-changing landscape relating to marijuana products and to hemp-derived products, especially CBD. We have helped them look at the risk of their various business models. We've worked through model contractual provisions and assisted a variety of companies to sort of look around the corner and say, okay, here's what the current status is. Here's when we see things starting to get some more certainty. But in the meantime, here are a few practical steps you could take, either through contracting or through due diligence, to make sure that you are protected. Because this is an industry, as Jim discussed, where there's a lot of change going on. There's also a lot of concerns about the supply chain and the products that exist. And with a lot of upstarts within the industry, the question of who's going to be the target of the litigation and who's still going to be around to the extent there is any litigation or other problems that develop is a really big question, more so here than in most of the food and beverage space. And we've also worked with a number of clients on just, the simple act of moving this product. As Lindsay discussed, there's a lot of concerns around this. If you're going through the state of Idaho, you need to be extra careful, for example. But there's a lot of other concerns because we don't have the legal structures in place, and a number of, really all of the market participants are moving much faster than any of the government agencies. And the question is whether the government agencies are going to put their foot down or sort of go along with the tide. And we've seen them largely going along with the tide, but not without some seizures along the way, not just in Idaho, but at a variety of retail locations in Arizona and Louisiana and a couple other places. So there is a lot of risk to sort of navigate through that is special to this area, and we're well positioned to be able to help clients through those issues.
All right, and with that, we will conclude our presentation portion and open it up to any questions.
Excellent. Thank you so much. Great presentation, and we have definitely received some great questions from our audience. I'll go ahead and start with our first one here. It says, recently the federal government declassified CBD from hemp off the Controlled Substances Act. Wouldn't that allow shipping of the CBD products across state lines?
And so that goes really back to the example that Lindsay gave. As far as the federal government is concerned, and again, with the caveat of what the product is, the answer should be yes. But if you have a sheriff in Idaho who decides that he or she is going to enforce Idaho's controlled substances statute, there's still the risk there, because that was the exact argument presented to the court in Idaho. And the court said, well, while it may be the case that it's decriminalized, it's only approved to be cultivated and grown in the United States under the USDA pilot programs. And because the USDA has not issued the regulations to really enact and make that practically available, this hemp could not have been grown through the pilot program because it doesn't exist yet. So it's therefore illegal, and that's why, in part, Idaho is allowed to enforce its law. So this is sort of the decriminalization versus maybe what you could call legalization of specific uses and products, where it's almost a non-enforcement position from the federal government. I guess it's stronger than that because it's actually taken it off the schedules. But it presents some of those same issues because there are still problems with the USDA pilot programs, with the FDA, and with, in our multi-government level system, state and local agency enforcement.
Good question.
Excellent. Our next question here, if the FDA has said that it's unlawful to add CBD to foods, why do I see CBD infused coffee, baked goods, etc. around town?
Yeah, so that's a good question. Earlier we showed that picture of the CBD coffee stand that Paul saw in Colorado, and I think that goes back to kind of, again, this patchwork, state versus federal law. So FDA would say, no, you can't add CBD to food, but again, FDA can only enforce if it's interstate commerce. So we have states like Colorado, and I talked earlier about the difference between expressly permitting, impliedly permitting, and Colorado is one of those states where it expressly permits CBD in food. So I suspect if you're seeing that, it's in a state where it's allowed, or, the other potential is that it's not a state where it's allowed, but we just have a lack of enforcement. That's what I would think is probably going on there.
Does make it confusing. Very good. The next question we have here is, if a CBD containing product also has an ingredient that has been determined to offer a therapeutic benefit, is it then okay for the company to make a therapeutic claim on that product?
Yeah, so the answer again is clear as mud. It depends. I think you're probably talking about a structure function claim, or at least you could be. So let me just give an example for those who kind of don't practice in or follow the regulatory space. A structure function claim would be something like fiber promotes regularity. We've seen those claims on products before. FDA doesn't pre-approve structure function claims, but you need sufficient substantiation. So if you had a product with, fiber, for example, in it and CBD, maybe that's not the best example, but roll with me here. You could make that claim, that structure function claim, assuming that you had appropriate substantiation, but probably equally important to the substantiation, you'd have to make that claim with respect to that other ingredient that you were talking about. You couldn't tie it to CBD because, again, FDA has said that you can't be making those kind of therapeutic claims, if that makes sense. So you'd have to get pre-approval. And again, particularly because of Epidiolex, FDA is even wanting kind of more than the structure function context. They're wanting something above and beyond that, the pre-approval.
Excellent. Our next question listed here is, has the FDA or USDA provided any information as to when we can expect further guidance?
I'll start with the USDA. The answer is no in a precise way, although they have made suggestions that by the 2020 growing season, so starting next spring, there should be a way to grow industrial hemp under the 2018 Farm Bill. And so, reading the tea leaves there, we are hopeful that we'll start to see those regulations coming out late summer or fall so that there is time to plan for the 2020 growing season and at least address a few of these examples starting at the cultivation and growth stages.
Yeah, with respect to FDA, the answer is no. We don't really have a clear timetable. I alluded earlier to that or spoke earlier about that May 31st hearing. Again, the agency kind of understood the urgency and the consumer interest, but they were really concerned about the lack of science. And so I just don't expect any kind of serious regulation anytime soon, unless there's some kind of, I hate to use this term, a health crisis, or at least what the FDA perceives as that. This kind of harkens back a little bit to, I do some e-vapor work, and if you look at kind of the history of how things played out there, I see some similarities. The agency moved very slowly, and then the industry kind of took off, leaving the agency in its path, and then we have kind of now this youth vaping epidemic, and now the agency is really shoring up enforcement. So, if we start having those kind of issues in this space, I could see the agency moving more quickly, but absent that, I think that things are going to be moving pretty slow.
Understood. Our next question we have listed here is, since including CBD in food and beverage products is not approved, would it be legal to sell a product that has the CBD separated from the food and beverage, thus allowing the consumer to mix the CBD into the finished product themselves?
I think it would all depend on how you're marketing it. That's a very interesting question. And, I hate to keep going back to this analogy, but this question just struck me as being very analogous. So for a while in the e-vapor space, we had a lot of companies offering 0% nicotine products with flavors, trying to get around flavor bans or hints of flavor bans, knowing that consumers would then mix later, and companies ran into problems there. So I think it's one of those gray areas. You might have a product that you produce knowing that that's what's going to happen. If you're making a claim on the label that that's what it's for, I think you could run into trouble. Again, I think it really comes down to how it's ultimately marketed. But that's definitely something we're seeing in the space right now with CBD oil for that exact purpose, and that's what consumers are doing. So I think that that's another area where, again, the way you market could come into play. And I would be very surprised if the agency doesn't speak to this in the future.
And there's and this is Mike. There's a related issue here, or I guess it's not really a related issue. This is the issue of how you market. If you're a retailer, for example, it's not just necessarily what you say on your website or what's on the container. For example, I've seen websites of manufacturers or processors of CBD oil who are selling the oil tinctures, which could be an example of what this is. And on their website, they say things like no taste or great taste or something like that. And I would guess a retailer is going to have a hard time arguing that this wasn't marketed for human consumption when the manufacturer on its website is saying great taste. And now, should the manufacturer be doing that? There's a whole other issue, and depending on which end of the supply chain you're in, there are different considerations there. But I think that's part of the due diligence and looking around the corner here. If you're going to be in this market, in a lot of regulated food markets, you have to think about those sorts of issues beyond exactly what you're doing and what it looks like on your shelves. Because if for example, a consumer Googles the product, they may find the manufacturer's website before they find yours.
Understood. Great. And our last question we do have here, the FDA has approved epidiol formulation of CBD only, correct? Also, FDA says it has psychoactive effects. Yes. If so, why does the US patent from 2006 on CBD formulations as a neuroprotectant exist?
I didn't catch the last part.
Yeah, sorry, say that one more time.
Sure, of course, no problem. So the last part was, let me see. So actually, just to state the whole question again, the FDA has approved epidural formulation of CBD only, correct? Goes on to say, also says it has psychoactive effects. Yes? If so, why does the US patent from 2006 on CBD formulations as a neuroprotectant exist?
I'm not familiar. Okay, I think you're talking about the U.S. patent. I'm not as familiar with that. For the first two questions, yes, it's been produced. It's Epidiolex was FDA approved. It's been just about a year ago, and again, that's for the treatment of seizures. So they're not approving CBD for the other things we kind of see it being marketed for. FDA has the only on-label use it's been approved for is seizure treatment. Beyond that, FDA has said yes, that it has. I think the question was psychoactive effects, so that is correct. The patent question, I'm not.
Yeah, and I'm not familiar with the patent either, but the psychoactive effects, a lot of time, and this is a bit of a shorthand, but when I was talking about psychoactive effects earlier, was sort of referring to the characteristic high of marijuana, and CBD does not have that type of psychoactive effect.
Yeah.
No matter how much CBD oil you use, you're not going to get that sort of a reaction from your body because of the way the cannabinoid receptors work. But there are effects on the brain, and so in that sense, there are in a very discrete sense psychoactive effects. They're just very different than the characteristic marijuana psycho effects. But I'm also not familiar with the patent. But a patent approval is going to be different from the FDA or other enforcement agencies,
Yeah.
And how they're going to choose to enforce things.
Excellent, thank you. That does conclude our Q&A for today. I want to thank Mike, Lindsay, and Jim again for your insights and time, and thank you as well to our attendees for joining us for today's webinar. As a side note, if you want to hear more about this topic or find out about Momentum's live events, please contact me directly at raquel@momentumevents.com or visit us online at www.momentumevents.com. And that's all. With that, all we have left to do is wish you a wonderful day and thank you again for joining us today.